Good afternoon. This is Joseph Jordan. I'm the attorney with the Jordan UCMJ Law Group, and I'm right here at Fort Hood, Texas, preparing for a couple of cases. And this has been a busy week at Fort Hood, and I want to talk to you a little bit about the report of the Fort Hood Independent Review Committee. I've taken some time to read through that thing. It's quite a lengthy document, and pulled some things out that I want to discuss with you as it relates to sexual assault in the military and in the Army on Fort Hood in particular. I'm not going to talk to you about the whole report. I'm just going to go through a few things that I observed, offer some reactions to it, and just give you some information, some of my thoughts and experiences on these matters. So, I'd like to start first with finding 4.5 in the report, where buried in that finding is an interesting quote. It says, "A knowledgeable CID source who contacted the FHIRC member, in addition to various other knowledgeable JAG interview sources, stated that a large number of sexual assault cases were lost or dismissed at court-martial, partially due to investigations that are rote and lack essential evidence." And later on it says that there was an 11% successful prosecution rate. Now, when I look at this particular line, this paragraph, it makes me wonder what one can take from that. And I, in the position that I'm in defending service members, when I read that, it makes me very concerned about what the implications are, which to me, the implications are quite simply that every sexual assault case that is claimed, every sexual harassment case that is claimed, is a case that is apparently true. We just don't gather enough evidence to get successful prosecutions. Well, I'm here to tell you that that's not how our system works, okay? Our system doesn't work that way. Under the Constitution, you're innocent until proven guilty, period. All right? Innocent until proven guilty. When I read this, it seems to me that we should be celebrating the fact that there's only 11% successful prosecution rate. Why? Because you're innocent until proven guilty. It's the state's burden to prove people beyond a reasonable doubt guilty of the offense that you charge them with. Plain and simple. That's what it is. The next point I want to discuss with you, which I find very intriguing, it says, there was also mentioned by Fort Hood JAG sources that the apprentice agents had great difficulty supporting warrants for crucial evidence. This is an investigative skill that was in short supply. Reliable CID and Fort Hood JAG sources stated that cases that involved search warrants or magistrate orders to obtain evidence were problematic, as inexperienced agents had difficulty developing and articulating necessary probable cause. I find that very hard to believe, okay? I find this statement in the report very difficult to believe. It's a basic investigative function to gather warrants. It's a basic investigative function to gather facts such that you have probable cause to write a warrant and also to write a charge sheet, for that matter. So this causes me to question, when they make this report, when they make this finding, that causes me to question, well, how is it that the OSJA can craft a charge sheet that meets probable cause standards? How can they do that? Because apparently they don't have agents experienced enough to even articulate probable cause in their warrants to gather evidence. Well, there's no commentary about that. It just doesn't make any sense. I want to look at finding 5. There's a lot of interesting information in there. I'm going to touch on a few things that I found interesting. The discussion in finding 5 and its subsection reveals at first glance that there's a concern for the fair treatment of both the victim and the accused during the military justice and administrative processes that these individuals go through. And what I find striking is the emphasis on the remainder of the report. What is that emphasis? It's on victims. It's not on the accused. The accused is the one that has the constitutional protections. We keep forgetting that. But the emphasis of this report is on the victim. They don't even call them alleged victims anymore. They call them victim. They make a claim. It's true. That's what this report is telling you over and over and over again. The report makes much of the investigating failings of CID, such as they are, yet the result of this report is to fire Fort Hood Command leadership at 3rd CR, 3 Corps, and suspend and begin investigating the leadership at 1st Cavalry Division. And what I find puzzling about that is it's these commanders who have to rely on the evidence gathered and the advice given by CID and by the OSJA, Office of Staff Judge Advocate, in order for them to make an informed decision on whether or not they should charge a case or not. And yet they fire these guys. Why? If you're saying that there's problems with the investigative process, and because of these problems, we only have an 11% prosecution rate, and your solution is to turn around and fire the commanders that are relying on this information to make the decision-making process, that doesn't make a lot of sense. The report also makes a big deal about how long it takes to investigate a case on Fort Hood. I find that amusing because the report spends no time on discussing how long it takes to test and analyze forensic evidence. How long does it take to test and analyze DNA? How many DNA tests are backed up at UCSIL? UCSIL is the United States Army crime lab, where all the DNA testing goes and other types of testing, other types of forensic testing. The report also has no commentary related to specific defense counsel concerns about the process, about what's going on. They don't care to hear what we think. They only care about prosecuting and putting people in jail. They don't really want to hear what the other side of the coin is. Here's where I'm going to kind of spend the most of my time on this video with, and that's finding 5.5 in the report. Soldiers feared that the SHARP program might incentivize false reporting. So in the finding, they spend some time going through why soldiers think that. And then they make a very interesting statement. They say, well, in spite of all these concerns that the soldiers have, there are safeguards in place. The soldier's 06 level commander must first conclude that there are reasonable grounds to believe that an offense constituting sexual assault has been committed against the person requesting the transfer or reassignment. I want to stop with that particular statement. Reasonable grounds. That's not even probable cause. It's just like, I heard it. Sounds plausible. Okay. That's what that statement means. This doesn't even use an evidentiary standard. It just says reasonable grounds. It goes on to state that, and the soldier is not entitled to dictate the location to which they will be transferred or reassigned. This phenomenon appears to be more mythical than factual. Well, I find that very interesting because in my experience, I'm 14 years as an attorney, practicing nothing but military law. 9 years as a private practitioner, doing nothing but defending service members worldwide in the Army, the Navy, the Marine Corps, the Air Force, the Coast Guard. And this is not my experience. I will tell you about the latest case I resolved in the Air Force. And it boggles my mind that they think that this is mythical. This is a mythical thing to them. Well, let me tell you what happened to a client I had who was serving at RAF Mildenhall. He comes under investigation for sexual assault. This investigation goes for roughly about 18 months before it even gets charged. It went through several review processes. In fact, the first review process, they decided not to do anything. Then they looked at it again and decided they were going to charge it. In my client's case, after the night in question, the alleged victim tells her friend, her best friend at the time, "Hey, I had a great time with him last night." And then 30 days later, she claims that she was sexually assaulted. Upon making that claim, she asked for a rehabilitative transfer to the States, to an Air Force base on the East Coast in the South. And she gets that transfer. And when she gets there, she says, "I'm still not going to participate unless this court-martial happens at another base." She didn't want it to happen at the base that she was stationed at. She wanted it to happen at a different base. Now, when she made her report 30 days after the alleged incident, she failed to tell OSI that she had told her friend she had a good time with my client. She didn't even mention her as a witness. We had to go dig that witness up ourselves. And wouldn't you know that this particular witness had a diary entry. She actually wrote it in her diary. "Hey, I think this is odd." She claimed sexual assault, but she told me the night after, or the day after, that she had a good time. So we provide this evidence along with another statement from another witness that knew the alleged victim very well, who knew that all she wanted to do was go back to the States so she'd be close to her mother. That's all she ever talked about. We present that evidence to government counsel and say, "Hey, you guys got some problems here. What do you want to do with this?" Because she lied, and we caught her in the lie. I mean, her claim was false, and we could prove it without a shadow of a fact, false. Without a shadow of a doubt, rather, we could prove it false. And I said, you guys are going to get ready to dismiss the case, or what are you going to do? And their response was confusing to me and somewhat fantastical. I got angry because their response was, I said, "Look, my client's life is on the line here." And they said, no, he's not. I was like, "He's not?" I got angry because my client was an African-American male and the alleged victim was white. And what chance does that young man have in society if he has a federal conviction, sex assault registry on his record, if he's convicted? His life isn't on the line in our society with all the craziness that's going on? That made me angry. And thankfully, we got a good result. They ended up dismissing the charge. But that goes back to this report. This report saying that this phenomenon appears to be more mythical than factual. No. The phenomenon is factual. And that's just one example. 90% of my caseload is sexual assault. Over the last 9 years, 90% of my caseload is sexual assault. All in the military. All of it. And what this report fails to help people understand is that these claims of sexual assault are subjective to the alleged victim. Just because you think you were sexually assaulted doesn't mean that you actually were to an objective standard. When you take an objective look at many of these cases under the law, these sexual assaults didn't happen. But the report doesn't spend any time talking about that. Doesn't spend any time talking about the objective standards, the evidentiary standards. No discussion about that. In my experience, there is absolutely no doubt in my mind that sexual assault has been weaponized. It has been weaponized. And the term that the kids are using right now, and I say kids, these young privates, young airmen, young Marines, young sailors, all the services, I get these calls every single day. And what they say is, yeah, they just sharped me. Or they threatened that they were going to sharp me. This term, sharp, is being used as a verb, not as a noun. Okay, it's being used as a verb. It's being used as a weapon, a threatening device. And in many cases, these kids are telling defense counsel like me and others in our defense bar that, hey, look, what happened had nothing to do with sexual assault, but because they didn't like what happened, they threatened sharp because they knew that was going to be taken seriously and they could get something out of it. And now, with all of these so-called protections for alleged victims, there's incentives to actually claim sexual assault. There's no doubt in my mind about that. And it's factual. It says, my notes that I came up with before doing this video, what I wrote down is that, alleged victims can always claim sexual assault. And they don't need evidence because they already know that the system's going to protect them. How are they going to protect them? They get a special victim counsel. They get their own sexual assault counselor. They get to bring a whole entourage of people to court with them, to coddle them, to counsel them, to make them feel good about themselves. Never mind that nobody critically analyzes their claim. And the investigators certainly won't do that. And do you think that you can expect investigators to critically analyze an alleged victim's claim now with this report? They get the opportunity to move or transfer to a base. And I know the report says that, they don't get to pick. Well, that's not entirely true. They can list where they would like to go. And then based off the needs of the service, they'll send them wherever they get to go. The alleged victim in the case I gave you about the Air Force, she got to go exactly where she wanted to go. And then at the end of their service, they get to claim military sexual trauma to the VA. And they get a monthly check out of that. So to think that this is some mythical phenomenon, and to think that sexual assault isn't weaponized, is naive. It's sweeping dirt under the rug. That's all it is. It's an inconvenient fact that they don't have an answer for, so they just call it mythical. It's a witch hunt. That's what it is. And sexual assault has become one of the easiest crimes that you can actually allege. It just is. Because, as I wrote in a blog a few weeks ago, in the Air Force, and now we're seeing it in the Army, if an alleged victim makes a claim and wants to go to court, regardless of the veracity, it ends up in court. And that's not what our system stands for. You're innocent until proven guilty in our system. There's no sharp exception to the Constitution. If there is, I missed that class in law school. Okay? There's no sharp exception. None. But apparently we're trying to write one in. And this is a pervasive attitude. It's a pervasive thought process. And now it's coming from the very top. A couple of days ago, right here at Fort Hood, after this report comes out and after all the leadership here gets fired, as I detailed earlier, what does the spokeswoman say? She says, "We hear you and we believe you." Those of you that have sexual assault claims and sexual harassment claims, we hear you and we believe you. The implication meaning everybody that has a claim has been harassed or sexually assaulted. Never mind the Constitution. Never mind the constitutional protections. We are conditioning our population to believe the victim, regardless of what evidence there may be. You need evidence to take someone's freedoms away. That's what you need. That's the bottom line. So, service members, I thought this stuff was going away. I honestly thought that sexual assault was starting to wind down. That's not going to be the case. The cases are going to ramp up. There's going to be more claims. There's going to be more trials. And my caseload is going to continue to be 90% sexual assault. Because this is the attitude. And it's coming from the top. So everybody be careful out there. Take this stuff seriously. And if you come under investigation, give us a call. Have a blessed day. Merry Christmas and Happy New Year.